My presentation will focus on the link between renewable energy and IP protection. And after, we'll see the main regional IP office in Africa. And after that, I'll talk to you in briefly about IP protection panorama in African countries in general. And on my last point, I'll talk to EU companies I'll talk about EU companies' achievement in the renewable energy field. So let's move on. Renewable energy. This morning, a lot of lecturers talked about renewable energy, and I, for myself, will just tell you that when you talk about renewable energy, you think of wind energy, solar energy, hydropower, biomass, and geothermal energy. When you are an actor in this sector, this means that you produce renewable energy. And when you produce a renewable energy, this activity involves technology, shapes, and designs. You will tell me what is this and why to talk about these things. It's about market. When you produce something, you have to make it available on the market. Be careful. My colleagues told you, everywhere your products and services should be available. Take care to go there and secure your rights. That can be done through IP right protection. And then IP right protection will concern your technology, how it runs, how you build it, and this may be called invention. And when it comes to its beauty, you'll have to be sure that when you create something, people will buy it. Then we'll think about the beauty of your product or the quality of your service. In this case, we'll talk about specifically in the shapes about designs. And this also can be protected through IP rights. After design, you will have designation. When you have a product, you have to give to your product or your service a name. I don't want to make a publicity, but all of you have on this table bottles of water. If I want to drink this water, I have to exactly this water, I have to know its name, its commercial name. And this commercial name, we call it in IP rights trademarks. And all these things can be protected through IP, and we call them inventions, patents for protection of inventions, trademark for the name of your product or service, designs for the shape, the beauty, and so on. I'll be going quickly to save time. When you want to protect, you have to know about IP protection, how you can get it. How IP protection is organized throughout the world at 3 levels. You have the international level, the regional level, and the national level. Why I'm talking about that? Because when you have IP rights, it's territorial rights. Your rights are territorial. So this means that when you are in a country, you are protected by this country, you have only rights in this country. Beyond, you have no right, unless you go to other countries to protect it. And to go other countries to protect it, we have what we call the regional level. The regional level is composed of, in Africa, 2 main organizations, OAPI and ARIPO. OAPI stands for African Intellectual Property Organization. The acronym is in French, OAPI. And this second one, ARIPO, is African Regional Intellectual Property Organization. This is in Zimbabwe, as my colleague told you. Then at the international level, you have WIPO, World International Property Organization. You have WIPO. WIPO doesn't grant you directly a title, but WIPO manage international procedures. If you want to protect a trademark throughout the world, you can go through what we call the Madrid Protocol, which is managed by WIPO. This doesn't mean that you have to go to WIPO in Geneva, but you can do it through your national office. Meaning, in the case of Cameroon, the national office is OAPI. Cameroon doesn't have a national office. Let's move on. I talked about the two main organizations in Africa, OAPI and ARIPO. What is OAPI and what is ARIPO? OAPI has been created in the years 1962, and at that moment, its name was WAMPI, and now it's since 1977, March, it has become an organization. Not before it was an industrial office, and now it's intellectual property organization. The difference between the two is that IP has two components. We have the industrial property and the artistic and literary property rights for authors, writers, for other artists. You have rights. This is literary and artistic property right. When it comes to industry and manufacturing systems, you have industrial property. When you put the two together, you have intellectual property. So all these, both of these organizations, WAPI and ARIPO, are intellectual property organizations. WAPI gathers 17 African countries and protects your patents, utility model, industrial design, trademark, commercial name, new plant variety, geographical indication, and copyrights. But copyrights are not directly protected by the organization. Copyright is protected at the national level. But the organization makes law and help national structures to build a copyright system. This is the chart of OAPI. We don't take time on it. I have a lot of slides, and I have put a lot for more than 14 so that when you have it, you can inform yourself. But for this presentation, I don't have more than 10 minutes, so I'll be rushing, please. These are the 17 member states of OAPI, and we can consider that OAPI is built on the basis, on a legal basis, which means that we have regional law and international laws. In OAPI, the regional law is one document which contains the body of the agreement and the annexes, which give you how to protect any assets of IP, like Annex 1 for patent, Annex 2 for utility models, Annex 3 for trademarks, and so on. And no organization, international organization, can be considered as such if this organization hadn't acceded to some international laws like the Paris Convention, the PCT, which is the international law dealing with the international protection of invention by patents, and the Madrid system also, the UPO for plant varieties, TRIPS for trade regards, international intellectual property rights related to trades. And these are some organization, international laws to which each office or organization have to accede to be considered as such and to be able to use these international procedures. Let's go to the characteristic of WAPI. WAPI, as I told you, is an organization with a unitary system, meaning that we grant at WAPI, they grant one title which is valid in its 17 countries. You don't have, for example, to apply for a patent or a trademark in Cameroon. If you want to do it, you send it to the representation of OAPI in Cameroon, which transfer your application to OAPI where the title is granted. This is valid for countries like Cote d'Ivoire, Senegal, all the 17 countries of OAPI. You don't need to send an application in each country. You just have to send your application to OAPI through your country, your member state country. I won't enter in the details of how your titles are registered. You will have this in the documentation. Coming to the finance, maybe you'll ask yourself where OAPI find money to manage all this. OAPI has one main source of income, which is the revenue generated from the processing of applications. Where to file? You can file directly at the organization if you are at Yaoundé and you are a national of OAPI, or you can send it by our representation in your home country, or you can use the services of an attorney. These are authorized agents that represent you by OAPI. And this procedure, passing by attorney, is compulsory for foreign applicants. To file now, you can just transfer your application by an electronic transfer of data at OAPI, which is not e-filing, i.e. precise, or by courier service, or in person, you can drop it at OAPI. The fees, you have to pay some fees. To get these fees, you have just to go on OAPI website and you have all the details about the fees you have to pay. This is OAPI. And I will have to answer to your question if you have any. But from now, keep it cold. Now we go to AfrIPI. AfrIPI is the African Regional Intellectual Property Organization, as I told you before. It has been established by Lusaka Agreement in 1966. And before, his name was AfrIPI and now as AfrIPI. It's the same as OAPI, where you pass from a regional organization, English-speaking organization, to a regional organization without any matter of language, but mostly you have in AfrIPI English-speaking countries, but you can have more than. And at OAPI, you have mostly French-speaking countries, but not totally, because you have some Arabic countries like Mauritania in OAPI, like Portuguese or Spanish countries in OAPI, Guinea Equatorial or Guinea-Bissau, for example. So the matter of language is not the most criteria for joining one or both of each one of these organizations. At AfrIPI, AfrIPI is composed of 22 countries, while OAPI has 17. And AfrIPI is a more complex system than OAPI. Juridically, the system of OAPI is complex but easy for the applicant. But in AfrIPI, you have the regional level, the organization, and the national level, meaning that in this AfrIPI system, country, so that you can apply for a regional or a national specific country in the AfrIPI system, which is not possible in OAPI system. If you apply for a title in the OAPI system, it's a unitary system. You have a right on all the 17 countries. At the same thing as OAPI, patent, utility model, trademark, new plant varieties, and so on. Let's move forward. And you have, after this, the chart of organization of AfrIPI, the 22 member states, and now the legal basis, as I told you, each regional organization should have a legal basis. And at AfrIPI, You have the RRA protocol for patents, utility models, and industrial design, Banjul protocol for trademarks, Mon protocol for trade, national knowledge, traditional knowledge, and expressions of folklore, and so on. These are the legal basis. The characteristic, I told you that the characteristic of ARIPO only valid for member states. If you file an application at ARIPO, the title which is granted is only valid for the state party to the relevant protocol. I've told you about several protocols. Every country is not part of all the protocols, and if you apply for a title and ARIPO granted this title, it's valid for the countries which are part of this relevant protocol. What's more? Procedure, they conduct substantive examination as OAPI, and the publication, this means that your application is published. Opposition phase, registration, and republication. This is, and in this system, they conduct an examination on some criteria which constitutes the basis of substantive examination. The finance at ARIPO is composed of the annual contributions of member states, which doesn't exist in OAPI system, and the revenue generated as OAPI from processing application under the protocols. Where to file directly as the organization has OAPI through the industrial property of a contracting state or through the attorney. How to file? They have an e-filing system. At OAPI, you have just a transfer of data system. There is a small difference between this. This last one at ARIPO is open to everybody. In the OAPI system, it's just open to a national representation and the authorized agents. So an individual cannot transfer its data directly to its application by data transfer application at OAPI, but they are trying to have an e-filing system. When you file, it can be e-filing, email to ARIPO, courier service, or in person, and fees are applied to your application. For as in OAPI, you have also this their website where you can find all the fees to pay. This slide, I won't last more on it because when presenting each of them, I've already presented the difference between the two systems, and we can move forward. Now we come to the landscape of IP protection in some African countries. In this part, we'll go from the east to the west and from the north to the south of Africa. In the east, we'll talk about Kenya, Rwanda, and Uganda. For the west, we'll talk about Nigeria and Ghana. And in the north, we'll talk about Morocco and Egypt, and the south, we'll talk about South
Sorry
Africa.
to interrupt. We still see the slides on ARIPO, but I think it's stuck. I don't know if someone can go forward because we still see ARIPO slides.
We are on slide 16.
We have to go forward on the slide that Mr. Kone is talking about.
Let's move forward, please. Again.
I don't know if someone is
again. Yes, someone else is doing it,
yes.
and I'm presenting
I'm sorry
on
to
my
interrupt.
computer. No, please. Go ahead, I'll lead you.
Which slide? Can you put the slides back on? But I don't know which you have in the clear.
Please, technical issues, but patience. PowerPoint
Go to 20.
show. Yes, move forward. More.
No, you're on slide 4 now. Away.
Stop.
So you can go to slide
more, move forward.
20.
Move. Until the tables, after the tables, you stop. Move. No, you are coming back. Go ahead. Yes. Continue. Continue. Yes. Go ahead. Go ahead.
So we have
No, back.
It's on the computer.
Back.
Yeah.
Yes, it's here.
it's here.
It's
Okay.
here. Now, just one more slide. Move forward. Now, we'll be talking about back one time back.
Okay. So, dear speaker, can you just hurry up? You're running out of time.
Let's go forward. Let's go forward.
Yes.
One slide.
More slides.
One.
But can you please hurry up, because we do have a schedule to keep.
Yes, it's okay. When we move, I make you a sign.
I think you're.
So we are talking about Kenya, Rwanda, and Uganda, and on this map you can see Kenya in yellow, Rwanda in orange, and Uganda in green. Move. Yes. These are the system of the three countries. First of all, I summarize. These three countries are all members of AfrIPI countries. We have taken them because in the AfrIPI system, it's not a unitary system. They may have some differences, but the criteria of appreciations are in the first column. You can have it. In this, you have the IP system, and you have the details in this line, and you have the legal basis, and you can see that in this part that Uganda is not part of Madrid system. Kenya and Rwanda are part of Madrid system. This means that if you want to register an international trademark, if you want to register a trademark by the international routes, it's not valid for Uganda because they are not member of the Madrid system. That's why I put this in color. And we can move on. They all protect the same rights as in the AfrIPI system. Now, we have other criteria I've taken into account so that you can be well informed, which are the IP matter protected patents and so on, filing application, how to do it internationally and so on, and opposition periods. I've told you about opposition period. What is it? When you apply for a title, your application is published, and anyone who think he has interest or his rights are infringed can oppose it to the registration of your title by the organization or by the intellectual property office. If he succeeded, your right will not be granted or registered. If he fails, your right can be granted. But even though he may fail, he can do what we call appeal. In the OAPI system, you have a commission of appeal, the High Commission of Appeal, as in the organization. But at a national level, in general, you go to court. These are countries, and you can see that you have to go to court. We pass now to the West with Nigeria and Ghana. You have Nigeria in green one and Ghana in yellow color. These countries.
Mr. Kone, yes, can you
yes,
quickly wrap up, please, because we are on a schedule, as I said.
Okay.
I'm sorry.
So in Ghana and Nigeria, you have the specific details, same as I have done. It's the same format I've done with the previous three countries. In Morocco and Egypt, it's the same criteria to summarize the landscape. And in South Africa, it's also the same. You have just to know that South Africa is not member of each of these regional organizations. The criteria of appreciations are the same. Now we come to the EU companies' achievement on the renewable energy field. We'll talk thoroughly about IP right filing and infrastructure building. We have just a pie chart here of WAPI in 2014 and in 2015, and you can see in the blue one here that European companies take the leads in filing application at WAPI. And this was through one route, the regional route. But in 2015, the international route entered in force at WAPI, Madrid Protocol. And you can see in the right side, the left side, that European countries went through this international route, which is Madrid Protocol routes, and there are 73% to adopt this procedure in just the first year. And you can see here the remaining in the regional routes. And now, what are the conclusions through this remark? Regional route and including the international routes. The conclusions are three. Companies in Europe lead the way in registering titles in the WAPI's area, and this trend remains the same until now. The entry into force in March 2015 of the Madrid Protocol at WAPI has been a success, and the promotion of international agreements are one of the components of the AfrIPI project. That's why EU companies, it's easier for them to go through regional.
Something's wrong with the sound.
It should be from
wrong with your connection.
We have already reached the end.
Okay.
In terms of infrastructure development.
So I'm sorry, Mr. Kone. We cannot hear anything anymore. Is there something wrong with your connection? Can you hear us?
Can you hear me?
It's another person. Sorry, nobody seems to. Oh, sorry. Okay. Please continue, but please do finish, wrap up, please.
Yes.
You have been talking quite a while.
We have just 2 slides on the companies which realize, which develop infrastructures in Africa in the field of renewable energy, and a showcase of energy access in Benin, where they have built a renewable energy installation. And just back.
Not back. We were on slide 41.
Okay, the last slide. Go to the last one, please. The last one. Again, yes, it's here. This is an installation in Benin done by an EU company to energize this village called Douhe. And now I would like to thank you for your attention. If you want to have more information about AfrIPI or Africa IP SME's Helpdesk, you have just to scan these QR codes. Thank you very much for your attention, and sorry for the time.